Hi, Steve.
Hey Sarah, how are you?
I'm doing well. I'm really excited for what you and I are going to discuss here during this session. It is a topic I know very little of, even though I've been through the process, mostly because I had really great professionals that I leaned on, which is what we're going to be talking about today. Actually, something to consider whether you need an attorney to buy or sell a home. And I think that this is a great topic because we're going to dive into some of the documents that you help people review, some of the processes that can become sticky, and that you'll really want to make sure you have an expert with you. So I'm excited to learn something today through this conversation. You, Steve, are part of our firm here at Nauman Smith. You've been with the firm for over 40 years, and you practice in multiple practice areas from municipal law to nonprofit law and many things in between. So I know you have a lot to share with us today on this topic. So I'm going to start us off by just asking that big question again. Do you need an attorney to buy or sell a home?
I think the answer is a qualified yes. It's advisable that you have an attorney involved, and at what stage depends on the nature of the transaction. You're not required to have an attorney involved, and frequently realtors will direct their clients, if it's a purchaser, to a title company and sometimes dissuade them from seeking legal advice. The most important thing is to have a legal review before the documents are signed, because all too often I have clients who come to me who have already signed an agreement of sale. They've received the disclosure statements, and it's right on the eve of closing, and they start raising questions. And at that time, it's a little bit too late because the ship has sort of left port, and for the documents that have been signed.
Yeah. And my question, I guess, you started to answer it there, is about the topic of time. And I know from my experience and from people close to me, whether they're buying or selling, that time seems to be the biggest issue. Once you start the process, it feels like it can go very quickly. So do you believe why sometimes people are dissuaded from getting an attorney involved? Is it because it adds time to the process, or what would be the reason not to?
Adding time to the process, and also the perception that it adds cost. For me, an ounce of prevention is worth a pound of cure, as they say. And in your typical vanilla type transactions, where it's just say a single family residence in a well-established neighborhood where the house has been bought and sold several times, you're less likely to require the services of a lawyer than if it's newer real estate, or if it's part of a where there's a homeowners association, or if it's a peculiar type of property. It's got something unique, whether it's got a lot of real estate or some other types of buildings on the property, all of which leads to a question of whether a more thorough evaluation is necessary. The most important documents for the purchaser to see and hopefully have a legal review of are the seller's disclosure statement, which is required by law under the Real Estate Sellers Disclosure Act, as well as the agreement of sale before it is signed. All too often, I have clients that come to me after they've signed the agreement of sale and on the eve of closing and say, well, what do I do? Well, you're contractually bound to what you agreed to in the contract. So it's best, if you're going to have a legal review, that it be done before you sign the document, not afterwards.
Very good. So those are two documents you mentioned that need to be reviewed, but I know that there are others. So Steve, could you share with us what are some of those other documents that should be reviewed and a part of this process?
Sure. Normally, the transactions are contingent upon financing. So the purchaser will be required to produce proof of a mortgage commitment, which basically is a statement that they've qualified for the loan that they need in order to close on the property. Now, oftentimes, buyers will come with what they call a pre-approval, and that's fairly common, where they've gotten an initial review from a lender and basically a tentative commitment to loan or to lend X amount of dollars towards the transaction. And that significantly enhances the ability of a purchaser to buy the property, because when they come with a commitment letter in hand or a pre-approval, that way the seller knows, well, I don't have to worry about whether they're going to qualify for the financing. We're in a good position to go forward and sell the property.
That makes sense. What about a title search and report?
Yeah, that's universally required. Oftentimes, either the realtor or a separate title company will be involved to search the title and issue what's called a title insurance policy with endorsements that protect the lender. Almost always, it's the lender that requires title insurance as a condition of the loan. The reason for that is the lender, if a title problem arises or a defect in the title, the lender doesn't want to have to pursue John Smith, attorney in Hoboken or whatever. They want the resources of a title insurance company to go after, and that's the value of having title insurance, because it's exactly that. It insures the parties against a defect in the title.
A defect in the title. I'm not sure what that means.
That would be like a lien or an encumbrance that
Okay.
it should be disclosed in the search. But if there's a lien that's on the property, certainly a buyer doesn't want to buy the property subject to outstanding claims, whether they be easements or a boundary dispute or something of that sort.
Interesting. So I know part of the process, of course, is having a home inspection done. So can you talk to me a little bit about what role an attorney might play in the inspection process, and what is disclosed or not disclosed as part of that part of the process?
Sure. Under the Pennsylvania Real Estate Sellers Disclosure Act, sellers are required to fill out a disclosure form. It's typically governed by statute, and there's certain disclosures that are set forth in there where the seller checks off whether these conditions are present or not, whether there's been any leakage of water, leaking roofs, any other type of damage or problem with the property. Now, a lawyer normally is not involved in the inspection process, but frequently, realtors, if they're doing their job, will advise the purchaser to get a home inspection. There are companies that specialize in that, and they go through various aspects of the property to make sure that there isn't a hidden problem with the property, like termite damage, water damage from a leaking roof or leaking wall, and any other type of condition that would be objectionable to the purchaser of the property. And they're the ones who are qualified from experience to do that. And in an agreement of sale, there are what they call inspection contingencies that you can check off, and typically there's radon, lead paint, and then home inspection contingency. Those can be waived by a buyer, but I recommend that they don't be waived and they be elected.
Yep. Your light goes off.
If I don't move often enough.
I know. Yeah, good. All right, I have another question, Steve, and I have to read it from my paper because, as I said at the beginning, this is something I've been through, purchasing a home. I've never sold a home, but it still feels like a lot of legal jargon, even though I know that this is standard speak. So my question is, do the standard provisions and agreement of sale provide adequate protection for the purchaser?
the answer is sort of a qualified yes and no. The standard agreement of sale form, you have to understand that usually there are forms that are approved by the State Association of Realtors, called PAR. They largely are what I'll call party neutral. In other words, they don't favor the buyer or the seller. They're designed to basically effectuate or facilitate the sale. Now, that said, they will contain provisions that refer to certain representations or the type of title that's being given. As I say, that's where the attorney comes in. It's usually advisable at least to have an attorney review the agreement of sale and the seller's disclosure statement if they can, just to determine whether anything's missing that a buyer would want in the agreement. Now, in the standard agreement of sale, there are provisions what are called, it's called an integration clause, which governs representations by the seller in the transaction. And typically the provision requires that any representation that's made during the course of negotiations merges into the agreement of sale and then into the deed when the title's transferred. So in Pennsylvania, a real estate transaction is largely buyer beware, and that's why the inspections are so important from a buyer's standpoint. Because if you don't pick it up before closing, too often the ship has sailed once you go to closing and accept the deed. For example, there's a provision, it's called representations. The buyer and seller agree that representations, claims, advertising, and promotional activities, brochures, or documents of any kind made by seller, broker, cooperating real estate licensees, or the employees / contractors of any of them are not part of the agreement unless expressly stated therein, nor have the buyer and seller relied on such in entering into the agreement. Then it goes on to say the buyer has inspected the property or has waived the right to do so and agrees to purchase it in its present condition unless otherwise stated in the agreement. So that's where the buyer really needs to be on their toes, that if there's a specific issue, it needs to be set forth. Most often when litigation arises between a buyer and seller, those clauses will be highlighted or emphasized by the seller and the realtors, basically saying, you know, it was incumbent upon you to get everything inspected that you wanted, you had concern about. You had a chance to do what's called a final walkthrough, which is one final walkthrough right before closing.
Yeah.
And that's when you really need to speak up if something bothers you, because once you go to closing and accept the deed, you're largely barred from any further recourse, unless you can prove that there's active fraud in the representation or misrepresentation. But those cases, as I say, once again, an ounce of prevention is worth a pound of cure, because the litigation that comes out of those breaches, if you will, or non-disclosures can be quite involved and quite costly. And particularly from the seller's standpoint, which sometimes is cause for concern, is normally a seller does not have insurance coverage against those types of claims. So while the realtors and other inspectors would have professional liability insurance, a seller who's sued for a failure to make the required disclosure is really hanging out there exposed and has to cover their own attorney's fees, and that can be quite expensive.
Yeah. It's not a place anyone wants to find themselves, I'm sure.
No, for sure.
My last question for you here is, are there any red flags that when someone is going through the process that, whether it's on the buyer or the seller side, that they should immediately kind of pause and get some outside counsel before moving forward. I mean, in an ideal world, they already have an attorney that's helping them read the fine print, make sure they fully understand what they're signing, going through all of these documents on their behalf so that they don't have to learn what all of these phrases mean, but they've got someone they trust. But anything that someone who is not already working with an attorney, if they see, they should kind of put their hand up and find someone to reach out to.
Well, the one document I keep going back to that purchasers really need to focus on is the real estate seller's disclosure statement, because that should highlight or identify any potential problems with the property. Again, also carefully reviewing the provisions of the agreement of sale is essential. Now, in last few years, with the residential real estate market being so hot, buyers are frequently putting up cash offers and waiving all inspections. Now, that's really, in my opinion, dangerous, because it really puts in a position of going ahead and closing and then finding out later that there's a problem, and then what do you do about it? A red flag would be, a seller who is anxious to get to closing, who tells you not to worry about the disclosure statements, that everything's been taken care of, or that they bought the property, say 10 years ago, and there were no problems, and there still are no problems. Those are red flags.
Yeah, that's good. All right, Steve. So you've covered a lot of ground, and I've been taking some notes actually. And this, of course, is going to be posted on our website, nssh.com. That's Nauman, Smith, Schisler, and Hall. Your contact information is on our website as well. People can find you on there or on LinkedIn if they have any questions. Any final words, final thoughts for this topic of what an attorney's role might be and whether they're really necessary as part of this buying and selling process? Any last advice that you have for us?
Well, certainly from a buyer standpoint, keep in mind the phrase, it's a Latin phrase called caveat emptor, which basically means buyer beware. And as a purchaser, you've always got to keep that in your mind, because if you don't pick things up in your inspection or your inquiries, you're going to be stuck once you accept the deed. And similarly, from a seller standpoint, I've been involved in a number of cases where there have been litigation resulting out of either inadequate, incomplete, or improper disclosures. A seller really needs to read that seller's disclosure statement carefully before filling it out, because if there is a misrepresentation of what's called a material defect, that can be a big problem. And I've seen a number of instances where a seller just sits down and sort of takes their best guess going through the form. Now, at that point, a good real estate agent will help them through the process and point out the potential hazards of an incomplete or an inaccurate seller's disclosure statement. And that's where the litigation usually focuses on.
Interesting. Got it. All right. Well, thank you so much, Steve. For anyone who watches this, I hope that you learned something new. Reach out to Steve or anyone here at Nauman Smith if you have questions, or if you're interested in working with us or learning what we can do to assist in this process for you in the future. So thank you very much.
Yeah, thank you, Sarah. Happy to help.